You have a string of academic qualifications. I remember interviewing you before, and I just get tired looking at the list. BProc, LLB, higher diploma in labor law, a master's, a diploma in corporate law from various educational institutions, tertiary institutions in this country. What did you do before you became a judge of the Labour Court in 2017 in the legal sphere, briefly?
Yes. Before I got elevated as a judge, I practiced as an attorney for a period of about 22 years, if I'm not mistaken.
And you had run a practice on your own account?
Yes, I did in partnership in some instances.
Yeah. What kind of work did your practice deal with?
I would say we were general practitioners. We did almost everything that we could or is thrown on us, as particularly before the or just after the I started that firm around 95, so it was shortly after the new country. So the type of work you would do as a middle sort of law firm, it will range from your civil road accident fund, contract, and so on. But I specifically in the firm chose to specialize in labor law.
And then you developed a special interest in labor law?
Yes.
When were you appointed in that court?
That would be the 31st of May 2017. Yes.
And how have you found the experience?
Of being a judge?
Of being a judge in that court?
Yeah, no, it's a daunting experience in a sense that particularly the labor court in Johannesburg, it's a hectic court. But here I am 7 years later. It seems I coped.
Well, I dare say you have more than coped. You seem to be thriving, if anything. Here you are co-authoring books, and how did you do that?
Okay. Co-authoring the book, it's an interesting story, but I don't want to bore the commissioners about the details. But one of the professors at the University of Namibia was apparently following some of my judgments. And he then made contact with me and said, I've read a number of your judgments. I want us to meet and share some ideas. And that would be around 2020, thereabout. Then we communicated telephonically and in some instances on WhatsApp. And then we agreed that let's put something which is a book related to the court in Namibia and the labor court in South Africa. That's how it came about, CJ.
Right. No, congratulations. That's a commendable achievement. I envy you, if anything.
Thank you, CJ.
We skipped some important steps. You served for 4 years as a CCMA commissioner.
Yes.
Before you, and you had served as an acting judge in the labor court since intermediately since 2007.
Yeah, since 2007.
Yeah.
I had acted in the labor court.
Mm-hmm. And you acted in the High Court as well?
Yes, and I'm currently acting at the High Court.
Since when?
Since the beginning of this year.
All right.
So that's the first term. Yeah.
So you have 3 terms in 2024?
Yes.
And
so
before
far.
that?
Before that, I acted in 2022. I think it was for a term, the fourth term.
All right. How have you found the switch to the High Court, where you do more generalist work?
Look, I don't think there was much difference. And I'll tell you why I'm saying that. In the labor court, in as much as you will deal with employment matters, you will on occasion deal with contract. On occasion, you will deal with your administrative law, and in some instances, a bit of contempt proceedings as a touch of criminal law and all that. So when I transitioned into a high court, I didn't find any difficulty, I must say, other than the fact that I'm no longer dealing with Sidumo all the time. I will be dealing with something different.
Yeah.
But nevertheless, motion is motion. Yes.
So I see that you've sat in the whole range of courts, doing civil and
Yes.
criminal work, full court, appeals, petitions, motions.
Yes.
The works.
Indeed. Yes.
You've written judgments.
Yes.
How many? Or both in the labor court and in the High Court?
Yeah. The last time I was here, it was you, CJ, who told me that the GCBU, they were counting about 300 judgments, and
that
now,
was why, so that you've accumulated on that list.
yeah. So I was given a list that has at least 40 judgments so far. So if you add that, you would be looking at about 340. If 300 was anything to work with.
All right, you're such a prolific writer. You've published other materials. You have articles in the area of labor law, of course. Where do you find the time to write all these things?
Yeah, I think this question also arose on the last occasion. You know, I perhaps I like reading, and as I read, I want to write something. So I'll spend sometimes a lot of time in my study writing something.
Okay. Judge President Mlam, do you have questions for this?
Thank you very much,
Candidate.
Chief Justice. Thank you. Judge Mshwana, the CJ took you through your work in the High Court. Just to confirm this, my spreadsheet suggests you've done 38 weeks since you started acting in the High Court.
Yes, that appears to be correct.
But what comes out very clearly is you've dealt with 4 special motions. That would be special motions each time you've acted, as well as 4 urgent courts. Wrong.
Yes.
That's
Indeed.
quite heavy.
Yeah. Well, coming from you, JP, is very rich to say it is heavy.
So you blame me for allocating your work to me.
Who else?
Okay. And you've done 1 week of opposed motions.
Yeah, I see it's 1 week, but my recollection is it could be more than that.
It should be more,
Yes.
because I think there are occasions where we would pull you from one
Yes.
role and put you there.
Yes, I remember specifically in May. Yeah.
We put you in an opposed motion in May.
Yeah, in May
In
when,
Joburg.
in Johannesburg.
Yeah.
Yeah, I dealt with opposed motion.
So let's say 2 there. But the point I'm trying to make is, as a rule, if you've got a special motion week in one term, we would give you one opposed motion week. If not,
Yes.
we give you one urgent court week. Because
Yes.
if we add those types of week, then we're killing you. You understand that?
Yes.
Yeah. So, but those are complicated work areas. But to you as a judge already, a 7-year-old judge, there was nothing new in terms of the intensity, because the labor court in Joburg is also busy.
True, I agree.
Right. And then in terms of judgments, I've given you a list of 40, but the only question I want to ask you about those judgments is, how long did it take you to write some of those judgments? Did you take 40, more than 3 months, or what?
Well, I can just look at one here, the Ramudzuli versus Commissioner for SARS.
Yeah.
I had that matter on the 28th of February 2024, and the judgment was written on the 26th of March. So
That's 3 months.
No, less than a month.
Yeah.
Yes.
Well, that's within the 3-month period.
Yes, within the 3 months period, sorry.
That's my assessment, having just browsed through all these judgments, that it took you less than 3 months. But can you confirm that for record purposes?
No, I can confirm that.
Right. So you've never had a problem writing judgments?
No, I never had a problem.
So you're one of those who's never received my love letter saying, where are the judgments?
Not at all. I am in the good books insofar as that is concerned.
Okay. Just stepping off that, Judge Mshwana, I think the only reason you are here, I want to think today,
Yes.
is because of the issue relating to your practice last year.
Yes.
Right. And can you tell the Commission what the situation is? Do you still have shares in that firm? Do you have a financial interest in that firm? Are you still involved in the firm you had founded? I think just assure us, the Commission here, because JP Wegley has also written here.
Yes.
But that's why we're here today. Can you tell us what's the situation?
Okay. Thank you very much, JP. Obviously, I did not know on the last occasion what could have caused my not being recommended, but I suspect that was the issue. So I'm just going to make 2 points, because I had read the transcript of the last occasion, and the 2 points I want to make is, and the first one very emphatically, I have no interest and I have no financial interest in that practice. It's been 7 years that I have been out of practice, so there is no interest at all, if that was the concern. And secondly, you do mention that my JP had written, I don't know what he had written to the JSC, but I did express the same sentiments to him, that I have not, and I will make it clear if I am called again, that no financial interest at all. The practice as we speak, I think I left about 2 partners or 3 partners. They changed the different partners now. Yes, I think that's what I can tell at this point in time. I don't know whether that answers your question.
No, it does. Thank you very much, Judge Mshwana. Thank you, CJ.
Thank you, JP. Premier?
Just 2 questions, maybe to follow up on this, what JP have just asked. In the last time when we were here, the matter that JP has just raised was really a serious matter, where it was not explicit that your involvement in that practice cannot be traced back and cannot be confirmed, that you are no longer part. I'm glad now you're emphasizing that indeed explicitly, that you are no longer part. did you take any additional steps or decisions immediately after your last appearance about this matter, or it remained as it was? Maybe it was a misunderstanding from our side.
Yeah, look, it remained as it was, and as I say, I don't want to rehash the debate we had, but the issue was centered around what is being owed, and that was it. And I think there was a confusion, thinking that what is being owed is amounting to some financial interest. So the situation is as is. Or as it was, rather.
The last question, Chief Justice, is from my selfish interest. Why this floor crossing from Methodist Church to Baptist Church?
Premier, you call it floor crossing, and of course it's a language that belongs to another area. But for me, I want to serve the judiciary to the best of my ability. And if I remain in the labor court, I might not have an opportunity to serve the judiciary to the best of my ability. I would have been confined, I said when I started, to the Sidumo situation. But at the High Court, I'm exposed to many other areas of the law. And I feel that my skills, if at all I have skills, are better placed at the place like the High Court.
Commissioner Trolley?
Just a follow-up question.
Sorry.
I didn't get the candidate answering the question. The question had nothing to do with Labour and High Court. It had to do with different churches.
Oh, okay. No, maybe I misunderstood. Yes, no. Please repeat the question.
I'm saying
the churches.
You are a staunch member of the Methodists. You just moved to the Baptist Church. I'm trying to understand.
Oh, no.
And I'm just saying it had nothing to do with this. Just my
yes.
selfish interest.
Well.
And why is Open Baptist? Is there closed Baptist?
No. Some years back, I used to live in Midrand. So the church I would attend there was the Methodist Church. Now, then I moved to Hartbeespoort. So I couldn't find a Methodist church close by, and the Open Baptist was the closest church to the Methodist Church. Sorry, I didn't understand the question earlier. Yes.
Deputy, I'm sorry, I didn't realize that you are acting as the president. Acting President Zondi. I'm sorry. Okay.
Sorry. Hi, good afternoon. Sorry, Jack.
Yeah.
I just want to refer you to page 9
Of
paginated
okay.
bundle. That's your questionnaire. Paragraph 16.3 and paragraph 16.4.
16 point. Yes.
Now, the questionnaire asks you to list cases in which you gave judgment that were unsuccessfully appealed against, and the 16.4 question asks you to list cases in which you gave judgment that were successfully appealed against. Now, but you said refer to 2023 questionnaire. But now, unfortunately, some of us were not here in 2023, and I'm not sure if even those that were here are still keeping the 2023 questionnaire.
Yeah. No, thank you very much.
Yeah.
Yes, I referred to that because at that time, and this was my thinking, it was too soon after the 2023 interviews, and not much had changed. But I picked up from the GCB that they did pick up those judgments, because for me it would have just been a repetition of what I had said at the time, because there was nothing new that was taken on appeal or overturned on appeal. So that's why I chose that route.
Okay. Thank you. Thank you.
Thank you, AP. Any questions, colleagues? Commissioner Ngqaitwa?
Yes, Judge Mshwana, I just want to put some of the objections that have been made against you. This one is not an objection, but it's a comment flowing from what the JP put to you. You said you didn't know what Judge President Workley said. Is that correct?
The JP, Commissioner Ngugaitobi, mentioned a letter. So I'm not, that's why I'm saying I don't know what the JP Wegley said.
Correct. Yes,
So
that's what
I
I
was
wanted to
referring to
assist.
that.
Yeah, no, that's what I want to assist you with.
Yes.
We had resolved at the JSC that he would follow it up with you to clarify the issue of your apparent ongoing financial interest in your former law firm.
Yes.
And then he wrote to us in October last year, in which he said that you were either on long leave or busy with your doctorate. But basically the gist of it was that he felt it was inopportune to invite you to chambers. And then he gave up and said, let the JSC deal with it directly with you. So the impression one gains from it is that there was some sort of lack of communication between you and him. Is it fair to say that you did not cooperate with him, or do you think that's unfair?
Yeah, it will be unfair. Why I say so? Shortly after the interview, JP Wegley, me and him, we come a long way. And he called me and told me about this meeting that you're mentioning. And he said that, can you write something for me to explain the position so that I can pass it over to the JSC? And my recollection is that I did write him an email in response to the issue that he say was raised with the JSC in his presence and in my absence.
You should have that email, I suppose.
I beg your pardon?
You should have that email you sent to him, I suppose.
Well, if I go to my records, I seem to recall that I would have shared it with the JP Mlambo as well, but it's been a long time since.
Yes, no, the
that
only
email.
concern is not the financial issue, but it's your failure to cooperate with the JP, who's been mandated by the JSC to engage with you.
That's why I said to you it will be an unfair statement, because I did. And that's why I emphasize that me and JP Wegley worked well together. We've known each other for many years. So he had informed me, and I wrote an email, which I didn't know that this issue would arise. Had I known, I would have brought the email with me.
Yes. The next one is an objection by a Mr. Zulu, who seems to have been a litigant in front of you in respect of a matter that you gave a judgment on the 1st of June 2023 without reasons. He wanted to appeal. He asked for the reasons on the 7th of August 2023, and you did not give him the reasons. Instead, what you did, you asked him to look for the transcript. What do you say to that?
Yeah, I think, Commissioner, that issue, as far as I can recall, has been before the conduct committee of the JSC, and
Yes,
they
but
have
there's an
reached,
appeal.
they have reached a ruling, and there's an appeal process. But in short, I gave an extempore judgment. And when the litigant wanted reasons, and I recall my secretary wrote a letter to the litigant and referred to a provision in the practice manual that when there are extempore judgments and you want the reasons, you have the responsibility to transcribe those reasons.
Who has the responsibility?
According to the practice manual,
It's the litigant.
the litigant. Yes.
So your point is you acknowledge everything, but it was up to the litigant to get the transcript.
Yes. Now, I think 2 points I'm making. One is that it has been raised with the Judicial Conduct Committee, and I gave the same explanation, and they ruled that there was nothing untoward. And I understand now, last week or so, I was told that there is an appeal by the litigant against the ruling.
No, I mean, this is not a misconduct inquiry. It's an assessment of your fitness for appointment. So this question is relevant despite the JCC ruling.
All right.
Yes. So, but what is your answer? Your answer is that you told them that they can get the reasons from the registrar's office.
Yes, that's what the practice manual of the Labour Court says.
Yes. Then there is a third one, which is from Mr. Makatu, who says that you failed to disclose a conflict of interest in a matter of South African custodial management versus, is it APSCO, in which you were a judge?
Yes, I recall that one. That very point was raised up to the Constitutional Court, and the Constitutional Court dismissed the application because that was the basis for seeking to appeal my judgment. But nevertheless, the transcript of those proceedings is one matter that I had virtually. I stated, and it was on record, and for that reason, the Constitutional Court ended up mulcting those applicants with costs, punitive costs, because it was there in the record.
What was in the record?
The disclosure.
Yes. So you're saying factually it's wrong, you made a disclosure.
Exactly.
Thank you. That will be all, Chief Justice.
Thank you, Commissioner Jozitube. Commissioner Kane?
Thank you, Chief Justice. Good afternoon.
Afternoon, Commissioner.
Good afternoon to you. I want to take up something that Acting President Zondi raised with you, and it pertains to the references to the judgments in your previous application. Your answer was that you gathered that the GCB had managed to access them. May I refer you to paragraph 7.1 of that GCB review, and just I could just let you know what they say. They say they didn't have access to...
What page?
It's at page 2 of the GCB review, paragraph 7.1.
On the paginated documents that I have, if I may be directed to the page.
I'm afraid I'm working off an electronic database.
Oh, okay.
I wonder, have you got the GCB review perhaps?
Not in front of me.
I think you're being assisted, so we'll just...
Yeah, no, let's
we'll
wait
just,
for...
wait a moment.
What paragraph?
Thank you. Paragraph 7.1.
Yes.
You'll see that they say that you referred to your previous application to which the current reviewing team does not have access. However, the following appears from the review of that previous application. So in other words, the GCB looked at the last time it reviewed you and uplifted some comments from its previous review, but they too didn't have access to your previous judgments. Had you read this report before you came here?
Which report?
The GCB.
No, indeed I did. That's what I was referring to.
Yes.
What they ended up doing was to review the very cases that were disclosed on the previous application.
I
That's
see.
why I was referring to.
Oh, I see. Thank you
Yes.
for that clarification. Now, on the real-time investment decision, you were criticized because you awarded relief which hadn't been sought by the one party, and so the other party had not even been given notice of that relief. Could you just give us your impression of whether that's a fair criticism and what you would do about such a situation at this stage?
All right. Thank you very much. Obviously, the LAC considered the matter and took a view that because reinstatement was not specifically asked for, then I, as the Kotako, ought not to have ordered reinstatement. Now, it's debatable in my view, and for the following reasons. There are authorities of the Labour Appeal Court, including the Constitutional Court, that says reinstatement is a primary remedy. And the only time that reinstatement may be excluded as a primary remedy is when the provisions set out in 1932 are present. Now, those authorities go further and say those circumstances would depend on the evidence that the employer would present. Now, in this matter, I had no evidence from the employer, and the finding I reached was that the dismissal was both substantively and procedurally unfair. And the primary remedy, which was available to the litigant, would have been reinstatement. That's why I went for reinstatement. But obviously, the Labour Appeal Court looked at it from a different perspective.
Yes, so in the same situation, you would do the same again?
I would say, look, given this judgment, on application of the stare decisis principle, I am bound by this judgment, except if perhaps I happen to sit in another higher court, in which event I would somewhat express the views that I just expressed. But if I were to return to the Labour Court and be faced with a particular situation, I'm bound by this judgment.
May I ask you also then on the next criticism of Solomon's case, the next paragraph, if I could just ask you a question about that criticism. Maybe the easiest way to deal with this is just to ask you the difference between a dismissal of an application for relief and an application for relief being struck off the roll.
All right. Thank you, Commissioner. Section 138(5) of the Labour Relations Act provides that where the applicant had referred a dispute and that applicant is absent, then the commissioner is entitled, or empowered rather, to dismiss the referral. Now that's the statutory provision. The CCMA rules repeat the same thing that is stated in the Act. So to a point that where a matter, if it was in the Labour Court, for instance, or in the High Court, where an applicant doesn't appear in court, ordinarily the application would be struck off due to non-appearance. Now, in the Solomon judgment, or perhaps before we get to the Solomon judgment, that is my differentiation. Dismissal is dismissing the action, and striking off is simply for lack of a better word, removing it from the roll of matters that were to be entertained on that particular day.
Any questions, colleagues?
Oh,
Do we have questions from the virtual platform?
None from my side, CJ.
No, thank you, Chief Justice.
Thank you. Judge Mushwana,
yes, CJ.
the interview is done.
Is
There are
it
no
done?
more questions for you.
Okay, thank you very much. Thank you, commissioners, for this
applying for
opportunity.
this vacancy. Good afternoon, Professor.
Good afternoon, Madam Chief Justice, and good afternoon to the commissioners.
I'm not even going to ask how you are after the hug. I saw you exchange with Judge President Mlambo. You should be fine.
I'm very well, Madam Chief Justice. Thank you.
Good. You from Matatiel?
That's correct, Madam Chief Justice, in the village of Ramuhlagwan.
Do you still go back?
I always go home, will always be home, Madam Chief Justice.
That's good to hear. You have listed 4 academic qualifications under your belt: a diploma in human rights, an LLB, an LLM, and an LLD.
That's correct, Madam Chief Justice.
Where did you obtain these qualifications?
The diploma in human rights, CJ, I obtained it from now the Northwest University, Mafikeng. Then it was the University of the North.
Yeah.
Then the LLB, I also obtained it from the same institution. I obtained my master's in international human rights law from the University of Notre Dame in the United States. And my PhD, I obtained it from UNISA.
All right. You have a very interesting CV. Your employment record starts with you being a security officer in
That's
2002.
correct. That's correct, Madam Chief Justice.
How long were you? Did you do this job? No, not for long.
I did the job for about 6 months before I found out about the Northwest University. I was in Rustenburg there.
Then you ended up doing articles
At the Legal Resources Center in Durban.
in Durban.
That's correct.
And you clerked at the Constitutional Court at some stage.
That's correct, Madam Chief Justice, between 2009 and 10.
For Justice Yacob.
That's correct, and we are still in contact.
How did you find that experience?
It was a stimulating experience, Chief Justice, and I think I grew significantly, especially in terms of dealing with legal issues. And I think to a certain extent, that experience happened to carry me through my acting stints, but it was a worthwhile experience.
So you decided to carve your career path in the academic world.
Madam Chief Justice, it was not by choice. I struggled with a module called bookkeeping. So I realized at the same time I was good in academia. So to me, given some other family responsibilities, I couldn't afford to pursue or rather persevere as a candidate attorney and try to pass the boards. Life had to go on, and I ventured into academia.
So you've built your way from assistant lecturer in January 2004 to professor and director in 2024.
That's correct, Madam Chief Justice, although it took me longer than necessary.
But you took 20 years. But that's not too long. You are a professor of law at the University of Fort Hare.
That's correct, Madam Chief Justice.
And your directorship is in the
UNESCO Oliver Tambo Chair of Human Rights.
Yeah. You are also a non-judge member of the Electoral Court.
That's correct, Madam Chief Justice.
I remember that you were part of a panel in a judgment that occupied our minds not so long ago from the
Indeed.
Electoral Court.
Indeed,
in
Chief
the
Justice.
vexed matter of the Electoral Commission versus Kondwe Party.
That's correct, Chief Justice.
I won't go into the merits of that judgment and what finding was made in respect of your majority judgment.
I respect your view, Chief Justice.
All right. So you have acted as a judge in the High Court now.
That's correct, Chief Justice.
For how long and where?
I was particularly based in the Gauteng Division, Pretoria. I started acting in 2022.
True.
I think I did 2 terms. Sorry, it might confuse me in terms of the actual dates, Madam Chief Justice. But to be precise,
Lambo will take us through that. That's his forte. But
that's
my calculations are that you have totaled up about 44 weeks. 44 weeks.
Yes, Chief Justice.
And in which courts did you sit? What cases were you adjudicating?
Chief Justice, I sat in motion court, opposed motions, unopposed. I did civil appeals. I did criminal law appeals. I did special trials.
What are special trials?
Those are the ones, Chief CJ, maybe you are located, it will run for a duration of 5 days or 3 days, depending on the dates that have been assigned to that particular matter.
So did you conduct any trials at all, civil or criminal?
I have conducted civil trials, Chief Justice.
Not criminal?
Not criminal, only criminal appeals. Full bench, yes, Madam Chief Justice. And I've written judgments in that regard.
You mentioned somewhere in your application form that you were admitted as an advocate.
That's correct, Madam Chief Justice. Under the old dispensation. But when the new dispensation came into effect, I did not do anything. I left it as is.
You mentioned that you occasionally did criminal work involving bail applications and trials related to excessive speeding.
That's correct, Madam Chief Justice. That was a very brief period post my admission, and it did not last that long. Hence, I used the word occasionally because I would not go every day.
All right. Well, you wouldn't have become a professor if you didn't publish extensively. So we won't deal with your academic publications. I'm more interested in your court judgments. You've had occasion to produce judgments.
That's correct, Chief Justice.
How many would you say you have produced?
I've produced 46 judgments, Chief Justice.
Have any of those been reported?
Yes, Chief Justice, I have 2 reported judgments, and one of those judgments was confirmed by the Supreme Court of Appeal. One of the judgments was overturned.
Well, I'm going to leave it to the representatives of the General Council of the Bar to raise the GCB's concerns with the quality of your judgments. They have a lot to say about that. Are you convinced that you're ready for permanent appointment as a judge? You're ready to become a judge?
That is the reason I'm here, Madam Chief Justice. I am ready.
And what would you say to anyone who says you are not ready and might perhaps benefit for more acting experience, as some of the professional bodies have said?
Madam Chief Justice, let me first acknowledge the constructive criticism that comes from the General Counsel of the Bar. The answer, Chief Justice, would be that out of all these three reports, or rather comments, there is a general trend. That trend is that I produce well-reasoned judgments, I produce judgments timeously, I'm able to conduct the court efficiently, and that I am independent. The only concerns, Madam Chief Justice, are related. In particular, this comment comes from the General Counsel of the Bar. It's in relation to my orders. And they rely at least, I think, on two judgments. Madam Justice, when J.P. Mlambo identified me as a raw diamond from the village of Matatiele, he threw me in the High Court in the deep end. The basis for that process was that I undergo through a rigorous process so that I can be familiar with the art of writing judgment. Try to convert my academic writing into well-reasoned and sound judgments, which I have mastered. There is always an area for improvement. Having gone through that process of drilling, here is the shining diamond in front of you, Madam Chief Justice. The judgments that I have presented before this commission, it shows significant improvement on how I craft my orders. To that effect, there is none of the concern raised with the judgments that I have submitted, especially insofar as it relates to orders. Madam Justice, I believe that this commission, respectfully so, should adopt a holistic approach. I bring in a triangular experience. That is my academic background, my acting stints, and my experience as a non-judge member of the Electoral Court. I believe that the entire experience has sufficiently prepared me to undertake and discharge duties as a judge of the High Court. Those are my submissions, Madam Chief Justice.
You were a legal editor with the public protector for a spell.
Yes, Madam Chief Justice, there initially when we were appointed, our duty was sort of editorial. But as time commenced, we were actually involved in the drafting of the reports. And in this regard, one of the reports that comes into my mind is the report titled Secure in Comfort. I produced the draft of that report, then you would send them to the Office of the Public Protector. I was then reporting under Professor Tulima Donsela. Then they would finalize the reports. So even in that capacity, I produce some of the reports. Madam Chief Justice, I hasten to mention that the reports that I worked on whilst at the Public Protector, none of them were taken on review successfully.
Right. All right. I'll hand you over to J.P. Mlambo.
Thank you, CJ.
Good afternoon, Prof.
Good afternoon, JP Mla.
Are you good?
I'm very good, JP. Thank you, and yourself?
I'm fine. I just want to confirm that I identified your CV. You had not applied to Gauteng. Some years ago, before I invited you, I think you had applied for a post in the Eastern Cape, if I'm not mistaken. Correct me.
It was the Land Claims Court.
Yeah, the Land Claims Court. So I saw your CV and I said, no, I must invite this person to come and act in Gauteng. You remember the discussion we had?
I remember them very well.
And that's how our relationship started.
Thank you, JP.
Now, you've acted in the High Court, mostly in Pretoria, but I'm sure you did some work in Joburg, or was it mostly in Pretoria?
Only in Joburg under the Electoral Court, JP, not in Joburg.
Not in the High Court, but the High Court in Pretoria.
Yes, JP.
Yeah. And the report you have in front of you shows the work areas you've acted in. You've confirmed you haven't done any work in criminal trial, but you've sat in criminal appeals, both full benches and full court appeals. Am I correct?
That's correct, JP.
And you've written some of them.
Yes. Sorry, JP, if I may identify something.
Yes.
I think there was a confusion with the spreadsheet, JP. In 2024, I also sat in an agent court. I think it was from 12 until 15 up until 19 January.
Yes. In fact, I was coming to that. The spreadsheet lists something like 4 weeks in one term, which is an impossibility. We can't put a judge to do 4 weeks of agent court in one term. Never.
I get it.
So my office has just confirmed that you actually did 2 weeks of agent court throughout your acting stints. Do you confirm that?
Yes, JP.
The one you mentioned and another one in last year, I think second term last year.
Yes, JP.
Yeah, so that's 2 weeks in agent court.
Thank you, JP.
And you've done 3 weeks of opposed motions, is that correct?
That's correct, JP.
And 2 weeks of special motions.
That's correct, JP.
I mentioned these because these are the heavy work areas where judges accumulate reserve judgments. You confirm that?
I confirm that, JP.
Now, how did you find acting in the agent court in particular?
JP, must admit that it is very challenging.
Yeah.
It's challenging in the sense that you get an agent application on top of an agent application. In other words, you need to be always on your toes. I remember at times I conducted some of the agent court matters during the weekend. But overall, it was a worthwhile experience, JP. And
Yes.
I think I have risen to the occasion.
No, you have. No doubt about it. And in the opposed motion weeks, how did you find that? There you get your files 2 weeks before, you hear them, even though you have other work, but you have the file so that you start preparing. How did you find those allocations?
JP, that was also good, but at times, in fact, my first acting stint there was that I felt that I was thrown into the deep end. I thought that you had mistaken me perhaps with someone who's from practice.
Yes.
But with the preparation and using some of my notes that I obtained from former colleagues, to this instant, I think Judge Stuart Wilson, whom I worked with at Seri,
Yes.
he had prepared me a sort of a starter pack. So I was able to survive, JP, but also got the shock when I realized that I had almost 10 reserved judgments when I left. But with the preparation of counsels, then the work also becomes a little bit busy, but at times demands more research, because when you adjourn, both counsels have to a large extent convinced you, and you have now to come to your own conclusion. as to which one is more probable and so on.
Yeah.
But it was a good experience, JP. Thank you.
Yeah, I think what is impressive about you, although you had a bit of practice, most academics struggle in the unopposed motion court, those who've never practiced, because that one requires a lot of knowledge of procedural law. But you've a whopping 13 weeks that you did in that court. And that tells me that you had a good handle of the work.
I am humbled, JP.
Now, in terms of your reserve judgments, you've just mentioned them. I did a quick scan. You record that you did a total of some 46 judgments. That's the list I have.
That's correct, JP.
Right. And some of them took you longer than 3 months. I can point them out to you if you want.
I still remember them.
You remember them,
JP.
yeah. I think only one took you 5 months. The others were 4 months, 4 months, 4 months.
That's correct, JP.
Yes, so you didn't have any that went over 6 months.
Yes, JP. And if I may expand on the ones that were slightly above 3 months, JP.
Yes, yes.
Those were matters that you find that are matters that are joined and they are heard together on the same day.
Yes.
Although the aspect of the facts to a large extent are similar, but the relief sought is separate. In other words, it's 2 applications at once.
Yeah. Yeah. No, there's just one, the one that took you 4 months. That's the Arrojo versus Greche matter.
Those were the matters, JP.
Yes.
It was a review application as well as a recusal application.
Yes.
If I may also mention, JP, the DB matter.
Yes.
That matter, JP, is the matter that involves RAF. Without going much, JP, the challenges faced by the Road Accident Fund need not be elaborated on.
Yeah.
But when that matter was assigned to me, the actuary report was outstanding. And already there were suggestions to request for postponement. But I stood my feet and said that this matter has been allocated for these particular dates, and with or without the actual report, the matter is proceeding. Unfortunately, the actual report was there on the trial day, but we proceeded a JP. At the conclusion of the matter, counsel was given specific time frames on which to submit the report. However, counsel still failed. It was only when I said, I am delivering my judgment with or without the report because I have given you ample opportunity. And it took longer.
But thank you for that. I have my own scoring metrics as to how I score candidates. And I want you to comment. You've said in almost all the work areas, except for criminal trials, but you've done criminal appeals. Taking account of the number of weeks you spent in the urgent court week, in the opposed motions and in special motions in particular, and not having acted in criminal trials per se, out of 7, how would you score yourself? It's a subjective thing. I'm just putting it to you to think about, you know?
Yes, JP.
Yeah.
JP, I would go for 5.5.
5.5, okay. Thank you very much. And in terms of, reserve judgment, it's a simple one. If you've delivered all your judgments before 3 months, out of 5, I give you the whole 5. But if there are some that went over the 3 months, but less than the 6 months, then you lose 1 point up to 4. So I think that would be a fair score, do you think?
I will sit at 4, JP.
That's what I'm saying.
That is fair enough, JP.
Yeah. Now, You are one of those applicants who didn't discuss their candidature for coming here with me. And I want it to be understood that I don't play a gatekeeping role. But it helps bite myself and candidates when they say to me, look, I have a nomination, do I accept it? And then we sit and talk. And the first port of call I do with candidates who come to me like that, I say, let's look at your acting allocations, right? And then let's look at your list of judgments. But more at that time, it's just your acting allocations. And I look at them and I say to you, realistically speaking, as head of court, I would not think you are ready to go. And I would point out why. There are a number of people who've gone through that process. But I say, however, should you disagree with me, you're welcome to apply, but I will put these concerns that I have with you during the interview. You understand? So I don't prevent anyone from applying, but I just advise them that I think you are ready, or I think you'll be ready after acting in this area, in this area, in this area. You understand what I do? You haven't had that engagement with me.
Sorry, JP, if I may come in.
Yes.
JP, I would like to refresh your memory. JP, at some time I wasn't acting, and I think we met in one of the official functions. And you said I should come over, and we happened to meet. When we met, JP, on that, I was sitting at 39 weeks. And you said, I'm ready to go, JP. You are comfortable with 39 weeks.
Yes.
Yes, JP.
Yeah. Well, I won't dispute it. I don't remember that.
Yes, otherwise I would have not come here without your approval, JP.
Yes. Yes. No, I don't blame you. I'm 60-something year old, so, you know. Yeah. I mean, under normal circumstances, I don't hold that conversation that way. As I say, we sit, we look at what's before us, and we convince both of us, say, well, are you ready? It's 39 weeks, but where? I can give one example with one judge who's in Joburg now. She'd acted for 3 years in the criminal trial courts, right? And when I took over in 2012, I said, I'm not going to recommend you because you are in a court that does a lot of commercial work. I want you to act in the other civil work areas, especially commercial work areas. She listened, and she's a judge now. She's one of the senior judges. So it helps to have that engagement, right? I don't dispute what you say. It may have happened.
Sorry, JP, I don't mean to exchange words, JP. And if you may recall, JP, my spreadsheet was one of the first probably candidates, which to me helped me to complete, and we emailed it to you in that regard.
Yes, but I do that so that every time you act, it gets updated, isn't it?
That's correct, JP.
Yes. So the fact that Tumi did it and emailed it is not of no moment. All it means is this a candidate who wants to become permanent. So we need to track his or her acting periods and in what areas, isn't it?
I appreciate it, JP.
Yes, that's why. So there are two other issues that I want to mention. And I want to assure you, I have no interest in the merits. That is your UJ issue. I have no interest in the merits as to what happened, who's right, who's not right.
Yes, JP.
My issue is when this litigation happened, you had already started acting.
No, JP, I hadn't started acting, JP. If I may refresh JP's memory, JP, at one stage, I think I phoned you, it was in the evening, just briefing you that, JP, I have this challenge going on, and JP, it ended there. Then I said I will keep JP in mind. But at no stage, it was during my acting stints at JP.
What is the date of the period, The order is 2023-03-22. That's the date stamp I have here. And you started acting in 2022.
20. Oh, sorry, JP. You mean the order was made before? I had already started. What happens, JP, with this matter? It comes settled. Then it resurfaces. It has its own timing. Just as it has resurfaced now. I know, JP.
I'm just interested in when it was in court. It has a 2023 case number.
Yes, JP.
You started acting in 2022.
2022.
Yes.
By then, JP, the matter wasn't there. It was resolved amongst the parties.
Right.
Fast forward, JP. I'm about to start at court. It surfaces. It dies down again as we entered the court. It settled before that. It dies altogether, JP. Come the JP interviews, it resurfaces.
For your information, I'm the one who requested the JSC to circulate these documents to you. It's not by anyone else outside here. So, as I said, I'm not interested in any merits as to who is right, who is wrong.
Yes, JP.
All I'm saying is, here's an order against you. You had already acted, I think, in 2022.
Yes, JP.
Or twice, if not mistaken.
Yes, JP.
And then here's an order, and I don't know anything about it, in the sense that you didn't come to me and say, in this court, this division that I'm acting, an order of this nature has been obtained against me. And I want to understand why you didn't do that.
JP, it must have fallen through the cracks, but I remember very well, JP, I'm not sure whether JP will recall. When this matter started, I did contact JP, that JP, I have this particular matter, but we are in negotiations, JP, for settling. Perhaps from there, JP, I did not come back to you that, JP, we have now settled. And because there is this constant resurfacing of this matter, we have agreed that we are going to make this dispute an out-of-court settlement and take it to court, so that going forward, no one will accuse the other. But JP, this answer forces me to go back a little bit back. When I left the University of Johannesburg, we had fought our fight, and I made an undertaking. The first one was that I'm not going to retract the statements, and I'm not going to apologize, because you subjected me to that, whatever behavior and so on, racism and so on. I signed an undertaking, we finished, the matter ended there. I joined Northwest University. After having joined Northwest University, the dean calls me, Pogo, there is this matter between you and JP. Then I report to the dean. Dean as
Look, let me stop you there.
Yes,
you can say that if you want, but that's not my intention. Like I said when I started, all I say I'm concerned about is you are acting in the Gauteng division, and there's an order that has certain implications about your behavior, especially your activities on social media, about statements you may be making against other individuals. And here's an order in which you signed an agreement of settlement to say you won't do this. And when I went into the fold-down case lines, I found that you never filed any answering affidavit to answer any of the allegations we were making against you. The matter was settled on that basis. I'm saying it was brought to me fortuitously that there is this order that has been obtained against one of your acting judges. And I'm saying to myself, but this is a division you're acting in. Why don't you come and say to the JP, hey, JP, this has happened? Isn't it? Because, when you want to become a judge, we don't want any controversies around you, because you're going to be sitting and dealing with a lot of serious matters involving society. So that's the only issue. I'm not interested in the history. To what prevented you from talking to me?
I appreciate the concern, JP.
Yes.
I should have updated you as that the matter was settled, and that was settled. That settlement was eventually made an order of court. I should have kept you updated, not only to say it's settled, JP, but also elaborate on the nature of the settlement. I appreciate the concern, JP.
Yes. And then there's the letter from the University of Limpopo. I was at a funeral of a former academic of the University of Limpopo. It's a person I was at varsity with at that university. So I went to the funeral, and then there was one person from the university there who spoke to me and said that we see that one of our former professors is acting in your court. I says, yes. They said, well, do you know what you're getting into? And then they started talking. I said, look, I'm not going to accept any verbal allegations. I want things in writing. And that's why that letter came. Right? Now, the letter has been availed to you. You've seen it.
That's correct, JP.
And you have your view about why those allegations are made. Right? So I'm saying to you, I have a duty as head of this court to make sure that the people I recommend to become judges permanently have no blemishes, if one may say so. I don't say you have blemishes, you've said whatever you've said, but do you want to say anything about the letter from University of Limpopo?
Thank you very much, JP. JP, I appreciate the concern raised by my colleague, Advocate Rapatsa Mashel. I know him as a brother and a scholar. JP, most of those allegations are unsubstantiated. They are baseless. It's character assassination, JP. During my tenure at the University of Limpopo, JP, I wasn't reporting to the author of the letter to disregard Advocate Rapatsa. I had my own direct line manager, who is my current dean, Professor Jozitube. JP, when I was headhunted from UNISA to save the LLB accreditation status of the University of Limpopo, I was tasked to be the leader of the Quality Assurance Committee. There is no way that as a leader, JP, I could have absconded from important meetings. To the contrary, JP, I singularly drafted a 72 pages draft improvement plan after I was reappointed to lead the task team. And I presented that report, and it was adopted. I took some of the comments from the older version of the report and incorporated them in the new report, JP. And eventually, we won the LLB accreditation of the University of Limpopo. But I must mention, JP, the Council on Higher Education was very clear in its condition of giving full accreditation at Limpopo. It said that the school was led by junior academics who have no PhD degrees, and that had to be resolved because it had an impact on the quality of education. After we had obtained the LLB, status. Advocate Rapatsa Mashele was appointed, contrary to the CHE conditions for accreditation, to be the director of the law school. And he accepted JP, that appointment, knowing exactly that he doesn't have an LLB degree. JP, at times, personal ambitions have to be subordinated
Yeah, can
to
I
the
stop you
collective
there?
good.
Can I stop you there? I think I've given you enough time to explain that background. But your departure from University of Limpopo, was it amicable?
It was amicable, JP, about a week ago. I was there. We had a conference. I went to support them.
No. All I want to know is,
JP,
was it amicable?
It was amicable, JP.
And from the University of Johannesburg?
It wasn't amicable at the University of Johannesburg,
Yes.
JP.
Okay. It's my duty to put this to you. You've given.
I appreciate it.
I've gave you time to explain yourself. You have explained yourself. CJ, I will end there. Thank you.
Thank you, JP. Premier?
CJ, I'm covered, CJ. Thank you so much.
Thank you. JP Khaled?
Thank you, Chief Justice, and Professor, here am I.
Yes, Commissioner. Thank you, Commissioner.
Thank you. Just a follow-up on what Mlambo JP raised with you. It is so that you are a member of the Electoral Court. And did you disclose the existence of the litigation and its settlement with the chairperson of the Electoral Court and those who appointed you in that regard?
No, Commissioner. That has not been disclosed, Commissioner.
That
wasn't disclosed, Commissioner.
I see. And any reason that you can proffer why it was not, maybe?
Commissioner, after we had made an out-of-court settlement, my understanding, Commissioner, was that this is binding upon me. And we have resolved our differences as we had agreed. And from there, Commissioner, I dusted myself and moved on. Commissioner, I appreciate the concern. I should perhaps been more delicate and not only to take it as being resolved, but brought it to the attention of my seniors. That was an oversight. Thank you, Commissioner.
Thank you for the answer. And secondly, the explanation that we've been giving regarding what's happened with the UJ, University of Limpopo, don't you think your appointment at this stage will drag the name of the judiciary into this kind of spat? Is there a way in which it can be resolved so that when you are considered and ultimately appointed, that it is clear? We don't have to see the judiciary being dragged onto the social media comments about this kind of issues. More so that without saying they are true, but that they relate to your character, there seem to appear to be allegations of defamation.
Thank you. Thank you, Commissioner, for the question raised. I appreciate it. Commissioner, if I may go back, I understand the seriousness of this nature. Commissioner, as you would see from my questionnaire, I was born in the apartheid South Africa. And at certain stage, I was part of Activism. However, I renounced my membership. As an academic commissioner, I could have chosen a route of only becoming a professor and focusing on my own personal development. However, as a young black aspiring academic, I couldn't focus only on my personal development when the injustices were occurring. I then, Commissioner, decided to be involved in issues affecting Black academics, and eventually I found myself being the center of attention, including being targeted. With that said, Commissioner, the allegations raised against me are very serious. But Commissioner, I had to come before this body to clear my name. The withdrawal of my candidature, Commissioner, would have meant that I have something to hide. Commissioner, I do not hide my academic activist. My writings, I am an academic commissioner. I express my feelings in various platforms. I have written about the Madam Chief Justice in one of my articles concerning transformation of the judiciary. I have written about the briefing patterns and produced a report. That is the commitment. And unfortunately, Commissioner, I must admit, being an activist, whilst you are pursuing your own career, it comes up with a price. It is the price, Commissioner, that I will pay. But going forward, Commissioner, I will be careful on how I conduct my activism. However, I will not subjudicate my conscience to the detrimental of the fellow Black academics who are victimized and eliminated in historically white education. I appreciate your, Commissioner. Thank you.
Yes, and you've also written about my judgment in Kivis Kroon at the Labour Appeal Court.
That's the same judgment, Commissioner, which raises the plight of Black people who happen to believe in another platform of medical care. Unfortunately, Commissioner, as I said, there is a price to pay when you stand for your rights and the rights of others in the New South Africa. I appreciate your comments, Commissioner.
Yeah, I must say I got more than I bargained for, but what I want to say is there a way that you can clear up these issues, not in this body, so that at least when you are appointed, we don't have to go back to these kind of issues? If it's not possible, then I will accept an answer.
Commissioner, thank you so much. Commissioner, I was under the impression all the undertakings that we have been doing, I was under the impression that we have somehow agreed. The difficulty, Commissioner, when we reached the settlement agreement, if you look at it, Commissioners, there is one condition that I'm not willing to form part of that agreement. That is to retract and apologize for sharing my lived reality as a Black scholar in a historically white university. Those appears to be the main things that keep making this matter to resuscitate.
Thank you, Prof. Thank you, Chief
Thank you,
Justice.
Commissioner.
Commissioner Ngota?
Yes, thank you, Chief Justice. Professor Pogo, I just need to put some of the concerns
Yes, Commissioner.
to you. You have debated some with Judge Mlambo. The first one is that there seems to be three primary objections. One is from the University of Johannesburg saga, where there was an application brought against you to interdict you from disseminating what they call were injurious falsehoods.
That's
and you
correct.
admitted that, and you entered into a court order
Yes.
in which you admitted to the interdict against you.
Sorry,
And
Commissioner.
now what we don't have are these injurious falsehoods that you allegedly disseminated.
Commissioner, may I respond?
Yes, please. That's the point of the question.
Thank you, Commissioner. The injurious statements, Commissioner, are the ones relating to my shared or my lived experience at the hands of the employees of the University of Johannesburg. I don't know whether Commissioner wants me to share that. It is now public information, Commissioner, because it is in a court file.
Yes.
However, I couldn't, out of my own volition, present it because it would somehow contravene the court order. Commissioner, I will be very brief. I will attempt to summarize this in a minute or two.
But no, don't make it a minute, make it 30 seconds.
Commissioner, what happened at the University of Johannesburg? When you have entered marks incorrectly, there is a form called a change of marks. And you complete that form so that it can be signed by your head of department and the dean. I happened to be in that situation where I incorrectly entered marks. Approximately 150, I took the change of marks forms for approval and we corrected the marks. Then, at a certain disciplinary hearing of a black colleague, I indicated that I also faced a similar problem of change of marks and I completed the change of marks. Out of that disciplinary hearing I was testifying, I was informed that I lied and I said I completed the change of marks. After completing the change of marks, Commissioner, you hand over to the faculty administrator, who is Miss Monica Bretz, for keeping and filing. It happened that when I handed over my change of marks, Commissioner, something that I always do, I kept my own records. But when I went now to request the original files, they were nowhere to be found. Right through, Commissioner, they were nowhere to be found. I asked the chairperson of the disciplinary, not the chairperson, but the employee relations, please, there is something wrong because you cannot change the marks in the system without having completed this form. I phoned my co-lecturer who said, no, there's nothing like that you completed. My head of department and someone else, they denied the existence of the marks. I said, it's fine. It sounded like a rehearsed response. Then, Commissioner, what I did, when I arrived at home, I scanned the templates of the marks and I emailed them to the employee relations. On the following day, I received...
I understand. What I'm really looking at is, where did you publish these injurious falsehoods that they are talking about? Because that's the internet is against your public announcements of these falsehoods.
Statements, Commissioner, I published them on Facebook platforms, on Twitter platform. I sent them to media houses. However, the media houses did not respond to them. And I also emailed some of them to my colleagues. And that's how I shared that experience, Commissioner.
No, that's fine. Now, then there is a second category of complaints, which is the circumstances in which you left the University of Limpopo, basically leaving them in a lurch, not attending to classes, not attending meetings, missing 3 meetings which were crucial in the university. And you've answered some of those questions that were put to you by the JP. Is there anything you want to add?
What I would like to add there, Commissioner Mugaitobi, is that in these meetings, we sign a register. However, the author of the complaint doesn't indicate the date of the meetings I've missed. And again, he doesn't indicate that at one stage I was even the head of that. And I wasn't reporting to him, Commissioner. The second one, Commissioner, it relates to businesses that I continued to be involved in a lounge.
Well, they call it a tavern.
Yes, Commissioner.
Yes.
Commissioner, I admit that I am in business. I have a lounge, Commissioner, which is licensed. It's called A2 Lounge Matatiel. I run a B&B commissioner. I have a logistics company commissioner. I have a farming company commissioner. Commissioner, at no stage during my acting stints, I was actively involved in these businesses. Even if I were to be involved, I can assure you, Commissioner, the workload at the Gauteng High Court will make it impossible for you to deliver judgments on time.
Yes, no, I think what concerned me with when I saw those allegations, there is the one where they say you have a general propensity to engage in social media and slander people there. I'm not saying that's correct, but that's what they're saying, that you have this propensity for social media and slandering people. And you are also engaged in private commercial enterprises. What concerned me was not the moral judgment on those activities, because I don't have the capacity for it. But it is the fact that you are already occupying a judicial role in the electoral court. And that has the implication of bringing the administration of justice into disrepute. And whether you had in fact applied your mind to that, because there is an inconsistency between holding a judicial role and being an active tutor warrior.
I appreciate that, Commissioner. Commissioner, if I may respond, the business interests, I'm no longer involved. The logistics company closed down some way back.
No, I understand that, but I'm saying that you were holding them at the same time as you were holding a quasi-judicial role in the electoral court. That's what really worried me there. It's not whether, I mean, as an academic, you can. There's no prohibition. I'm just worried about what people will think if you are sort of two-timing them.
I appreciate the concern, Commissioner. It doesn't paint a beautiful picture.
Yes, and it's the same thing with your propensity for Twitter and Facebook. It may be that the things you're saying are correct, but the public will think differently about the judicial system if one of their number is busy fighting other battles on Twitter. Which comes back then to the point made by Justice Tlaletsi, which is whether you shouldn't actually be taking time off, the cooling off period, to, I wouldn't say mature because that's not my space, but to let these events percolate and settle, and then to come back maybe in a year or two. At the moment, it looks like the transition is too soon and too sudden. Do you have any comment on that?
I appreciate the concern, Commissioner. Being an academic activist, it comes with a price, Commissioner, and I appreciate your concerns are quite correct, Commissioner.
All right.
Chief Justice, may I follow up, please? Good afternoon, Professor Puko.
Good afternoon, Commissioner.
Professor Puko, you're aware that I have great respect for you, but I am concerned that despite what you're saying, you don't quite appreciate the severity of the concerns that have been raised with you. And can I just demonstrate one issue? You've now indicated that you've had diverse business interests ranging from a lounge to a B&B to a logistics company and to a farming company. I'm correct?
That's correct. Please proceed, Commissioner.
Can I ask you to go to your form and specifically to paragraph 1 of your form?
You may proceed, Commissioner. I have the form in my memory.
You see, none of this is reflected in your form.
Commissioner, it's there under AA2 Lounge. That business, all these things, they fall under it. Then the farming commissioner, it's a family business, a sort of informal, not trading and so on.
You see, Professor Puko, you disclose in paragraph 1 of section 3, you disclose the fact that you're a director in the company you list, the private company you list there.
That's right. They all fall under that company, Commissioner. Sorry, I wasn't clear enough.
No, I understand that, but what is required by section 1 goes further than that. It goes further than you disclosing just your directorships. It's also asking for your business interests. And so what I'm putting to you is that you had a duty to break down your business interests, to give the Commission a sense of the extensiveness of your various interests.
I appreciate the concern, Commissioner. I was not clear enough. It's one company, then under that mother company, you have all these various clearly, as I explained them now, Commissioner.
And you
I
see,
take the concern.
it gets worse, Professor Puko, and I want you to very seriously consider this. If you go further down in the form, section 4, paragraph 1,
Yes, Commissioner.
asks you, are there any circumstances, financial or otherwise, known to you which may cause embarrassment in undertaking the office of a judge? Now, you're an academic, you understand the breadth of the term embarrassment.
That's correct, Commissioner.
Your business interest, for example, in a lounge, that's something you should have disclosed under that section.
Yes, Commissioner, I appreciate. I should have elaborated more on the company because commissioners are not aware of the company.
And more importantly, Professor Puko, the settlement agreement that we were provided with after you put in your application, the settlement agreement should certainly have been disclosed in a number of sections in the form.
Commissioner, I must admit, I struggled with that one. I think somewhere it doesn't come out in my explanation in the form, but there's where I keep making reference to transformation activists and so on. But I appreciate, Commissioner, it should have came out very clear so that from the face of it, it is clear that this is a standing order.
You see, Professor Puko, this is where you and I are losing each other. For me, this has got nothing to do with transformation activism. This has got to do with the fact that you entered into a settlement agreement, which was made at order of court, and that agreement imposed certain obligations on you.
Yes, Commissioner.
And so you know that if ever you breach any of the terms of that agreement, that's a breach of a court order.
That's precisely correct, Commissioner.
And for that reason, Professor Puko, it really ought to have been disclosed under 4.1 of your form, section 4.1. It also ought to have been disclosed under section 4.2 of your form. Sorry, no, it's not a convicted of an offense, but you certainly are bound by a court order, which ought to have been disclosed in your form.
I appreciate the concern, Commissioner. I did not understand in that way, but I get it. It's clear, Commissioner.
So really, just to wrap up what I've been putting to you, it goes beyond raising concerns about your conduct generally. What I'm raising with you is material non-disclosures in your form to the JSC. And that's what I want you to address.
I appreciate the concern raised, Commissioner. I don't think I can take it further. This should have been come out clearly from the face of it, Commissioner.
Thank you, Chief Justice.
Thank you very much, Prof. Good afternoon.
Sorry, Commissioner. Yes.
It's Minister Smelan.
Thank you, Commissioner.
Have you deactivated all your social media accounts as we talk today?
As I sit here, Commissioner, I haven't deactivated anything.
When did that happen?
No, sorry, Commissioner, I'm saying I have not.
You have not?
Yes, Commissioner.
Okay. Do you understand the importance maybe of from emanating from today's discussions of possibly not having one?
I fully appreciate it is something to work on and address, Commissioner.
Thank you very much.
Chief Justice, thank you so much. Good afternoon, Prof. Poko.
Sorry, Commissioner, which side are you on?
This side.
On your right.
Commissioner Lekhanyan.
Commissioner Lekhanyan.
Yeah. Good afternoon, how are you?
Commissioner, I'm surviving under the circumstances. Thank you so much.
Thank you so much. No. It's just a follow-up to one of the statements that you made. Maybe you can help us to elaborate on it when you say academic activism comes with at a price. What do you mean by that?
Commissioner, my activism perhaps could have been approached in a different manner, especially if one is considering appointment as a judicial officer in the High Court. Perhaps the manner of approach could have been taken in another way, Commissioner. But I understand that fighting for other people doesn't necessarily justify the manner in which you engage on it. That's what I meant, Commissioner.
You want to concede that your approach could have been defective?
I fully appreciate, Commissioner. My approach could have been handled better, no matter how the circumstances were. Perhaps at the palms of my reaction, I just decided to act at that moment without fully appreciating the broader picture.
No, thank you so much, Chief Justice. Thank you.
Thank you, Commissioner Lefanya. Do you have questions from the virtual platform?
Yes, I do, Chief Justice. Thank you very much. Good afternoon, Professor Poko.
Good afternoon, Commissioner Marumwakai.
Perhaps maybe it is opportune time for one to disclose that we know each other very well and we work in the same space. I want to take you to your document, and page 112 in particular. The judgment that you penned.
Sorry, Commissioner, if you may direct me which bundle?
I would think that there is only one bundle, but where you have your decided cases, your judgment. B versus R. It is in page 112. Paginated page 112.
I'm there, Commissioner.
Yes, this is the case of B versus R, and in particular paragraph 25 of that decision. This is a case that dealt with forfeiture of benefits. Yeah. And in paragraph 25, we say that the issue of fairness also does not come into play. In other words, in the remedy of forfeiture of benefits. The question that I want to ask you, and you are quite right, by the way, but the question that I want to ask you, forfeiture of benefits is one of those common law remedies that have been codified in the Divorce Act. Is there a need to develop this particular remedy, and is it constitutionally compliant to the extent that the concept of fairness is not part of how it should be understood?
Thank you, Commissioner. Commissioner, I think if it were to be argued in that way, and particularly considering issues such as Ubuntu, compassion, and so on, one would be tempted to agree with you that the issue of fairness in the adjudication process perhaps could play a major development.
Oh, that's where you leave it. Okay, no, that's fine. CJ, let me leave it there as well.
Thank you, Prof. Yes, Acting President Zone.
All right. Yes, good afternoon, Professor Poku. I'm here.
Good afternoon,
yeah,
DJP.
It's Just my advice to you, just a comment, it's not a question. Based on what my colleague on my left has advised you to do, I think that the best thing for you to do is to keep away from social media, because, you know, it has got, it doesn't give one an opportunity to think and reflect. You react to something immediately before you think about the consequences of what you are going to say. So my advice to you is just, if you're really serious to progress in life generally, just stay away from social media, because it has got so much, it attracts so much negative energy, the energy that you don't need. So yeah, that's my advice to you. I wasn't aware that there were such issues because I was not informed of. I was not told that there were. You had some challenges with your former employers. Thank you. That's all. That's my advice to you.
I fully appreciate it, Chairman of the Electoral Court. Madam Chief Justice, Commissioners, I have considered the deliberations and I have considered the engagements between you and myself. I have taken your advices on board. JP, I've taken the advices on board. With those few words, I'm going back to do a homework. And I withdraw my candidature. I thank you, Madam Chief Justice and Commissioners. Thank you.
JP Mlambo.
CJ, before the Prof leaves.
Yes, JP?
I discovered you. You said that. And I've invested in you. I hope you understand that I was duty bound to the institution of the judiciary and to the court I lead that this engagement happens. Do you understand that? And I want to say, to encourage you to say, when I reach out to you to say, come, let's talk. Because I don't want my investment in you to be lost. And that you will respond. You understand that? I've got nothing against you personally. You understand that? I just wanted to say that, CJ. Thank you.
Thank you, JP.
I appreciate JP. Thank you so much. Thank you, Commissioner.
No, I've not released you yet.
Oh.
don't rush off.
My apologies, Chief Justice.
I just wanted to say that I know where you come from. I used to do circuit work when I was still in the High Court in the Transkei, in Maluti. I'm quite familiar with that area. I know that dusty, arid village from which you come, and it's quite remarkable that it's produced a professor who studied overseas, who's achieved all the things you've achieved. You described yourself as a raw but shiny diamond, and that's what you are. So what has happened here today should not discourage you. I just want to give you that that caution. There's still a lot you can do, and you can still come back. But do pay attention to the advice given to you by acting President Zondi. Social media is the bane of this generation. Is the bane. Why is the internet and all that it comes with is good. We appreciate the benefits it has brought, but it has caused huge damage to our young people for various reasons we don't have time to traverse now. So keep away from social media, young men.
Thank you very much, Chief Justice.
But thanks for this honorable decision.
Thank you,
You're
JP.
excused.
Let's switch it on.
I'm sorry, just bear with us for a minute. I'm waiting for the minister. Good afternoon, sir.
Good afternoon, CJ.
How do you pronounce your name? I'm avoiding mispronouncing it.
Tupayatlase.
Tupayatlase.
Yes.
Thank
CJ.
you.
Thank you.
Tupayatlase.
I know it's always difficult. That's why they only call me TT, CJ.
I can't call you Mr. TT now, can I?
Yeah, no, not today, not today.
You studied BU recent LLB degrees.
That is correct,
At,
CJ.
You obtained the BU recent, that university that used to be known as UNIBO.
Yes,
And then you did the LLB through UNISA.
through UNISA, CJ.
Was that while you worked as a public prosecutor?
Yes, that is the reason I worked as a prosecutor, DJ. Subsequently a magistrate.
Oh, yeah. So you were a public prosecutor for 4 years, about 4 years?
Yeah, about 4 years, 1985 to 1989. Correct.
Then joined the magistracy.
That's correct, CJ.
And you were there for about just over 14 years?
Yeah, just over 14 years until 2005, CJ. Then I resigned.
You went to work for, was that the private sector?
The Universal Service Agency, CJ, is an agency of the Department of Communication, what is now called Department of Digital Technology.
Oh.
It is created in terms of, in the Electronic Communications Act, there is a chapter that deals with universal service. So the Universal Service Agency administers the fund that is created. The Act provides that a certain percentage of every licensee is obligated by law to contribute towards that fund. That fund is called the Universal Service Fund. It is a fund that is supposed to be tapped by the same licensees, your telcos, when they go into rural areas. The idea being that with a recognition that in those areas, from a commercial and a business point of view, they may not make money. So as a result, then when they want to expand electronic or telecommunication infrastructure in those areas, then they are required, then they can tap into that fund. In addition to that, every licensee, telco in the country, has what we call universal service obligations. And those obligations are also then monitored by this particular agency, the Agency of Department of Communications. But it has a separate board, it has a CEO and all that. But I was only there for 18 months.
Yeah, as if you were in the Legal and Corporate Affairs Department.
That is correct, CJ.
Giving them legal advice.
That's correct, CJ.
Well, I doubt very much that my village has ever benefited from this body.
Yes, CJ, you know that it's one of those things that on paper they look very good, but the implementation is always a challenge.
Something else, yeah. Then you left them and joined Neotel.
Yes, Neotel at a time was just been licensed. It was envisaged that it was going to be what was then called SNU, a second national operator. And the minister licensed it, and I worked there. It also, as I've indicated, also had those obligations. So the idea was I would go there, and we started the department, community service, that was to deal specifically with those universal service obligations. I was not strictly within the legal. There was a separate legal department at that time. Yes.
But then you went back to the magistracy.
CJ, yes. For the first time in my life, there was a point I was not working. What happened is that Neotel did not really get off the ground to become a successful company. And at the end of 2010, we were offered severance packages. I decided to take that, and I was home from January of that year until June when I applied and for an acting position, and I went and worked for a year in Klerksdorp. During which period permanent positions were advertised, and thereafter I applied and I was successful. I went to work in Bloemhof, so as a head of office and the only magistrate in that district, doing both Bloemhof and Christiana.
So you went back to the magistracy and never left?
Since 2012 to date, I never left again.
And you've worked your way all the way up to regional magistracy?
Yes, I must appreciate the considerations that the department gave me. I think my past experience was never ignored whenever I had applied. So as a result, I became a senior magistrate for Krugersdorp and then acted as a chief for 5 years in Randburg. And then since last year, I'm a regional court magistrate in Soweto, Protea.
So you've been a magistrate for about 27, 28 years?
That is correct, CJ.
Running the criminal and civil court?
Yes, CJ.
Various stages.
Various stages, but especially, let me say, when I worked in Garankuwa, at one stage, just on my own accord, I decided that I wanted to do civil work. At a time, they still had what was called Justice College when they trained, and from that moment, the bug bit me, and I've been mostly in civil work, which, of course, then. And the experience came very handy when I was the only magistrate in Bloemhof, because then I had to do everything.
Yeah, and that experience paved the way for you to be appointed to the Rules Board.
Yes, CJ. Yes, CJ, to the Rules Board, yes.
And you list subcommittees in the small claims and magistrates court in which you've sat.
Yes, and also the cost committee, subcommittee. The Rules Board operates with subcommittees. Each subcommittee does a particular work, and then of course there is a meeting of the whole Rules Board, chaired of course by a judge from the SCA, presently Justice Ndambuza.
Yes. And you train aspirant and serving magistrates under the auspices of the SAJ?
That's correct, CJ.
You have acted as a judge?
Yes, from third term of 2021, fourth term of 2021.
2023?
2021.
Sorry, 2021?
Yes.
And for how long were... No, it was not just one stint, was it?
Yes, in 2021, I acted for a full term.
Mm-hmm.
In 2022, it was also for a term. And it was for 2 terms. And then in 2023, I acted also on the 4th term.
Was your last acting stint in the High Court in 2023?
2023, last term.
And you claim to have presided over civil and criminal trials, opposed and unopposed motions, family court, criminal appeals.
That's correct, CJ.
And road accident fund matters.
That's correct, CJ.
Did you produce any written judgments?
I have I've counted about 40 judgments during the 37 weeks that I've acted.
Yeah. Have any of those been reported?
No, CJ, only published
In Safely?
in SAF, in JDR. I know the CJ will ask me why I didn't mark them reported, but in a majority of cases there, I said, the consideration was always, I was confirming principles that higher courts or courts with more than one judge has dealt with. So I've never thought it wise that there was anything novel that any of those judgments produced.
Well, experience has shown that it is not only judgments on novel issues that may be useful, especially to the, to the lower courts.
Yes.
So if you've spent a considerable amount of time and did good research in the subject area you covered, if it's good to mark it reportable, you can sense when a judgment is reportable. Then it's up to the publishers to ignore it if they don't think it's worth publishing in their books.
I appreciate and accept that advice.
We've lost a lot of good judgments because people don't mark them reportable.
But on the same breath, with the present digital publications, much as they may not be reportable, I take that they are available to be considered.
Yeah, it is easy for people to pick them up.
Yes.
Okay. I'm going to give Judge President Mlambo a chance to ask you questions.
Thank you, Chief Justice. Good afternoon. Ntate Tupayatlase.
Good afternoon, JP.
Did I pronounce it correctly?
You have, JP.
Thank you very much. I know you told me that it's been a painful wait for you. We apologize for that.
Yes, but I also added that, it's the first time that I've been ordered food when I came to an interview. Thank you for that.
Yes, you did say that after a number of times applying. Or it's the first time to apply?
No, it's the first time.
First time you apply, yeah. So you must have a magic wand to apply for the first time when you are shortlisted. My spreadsheet says you've done 37 weeks totally acting.
I agree with it.
You agree with it. And all of those acting stints have been term long.
They have been term long, see.
Yeah. And the reason they've been term long, you're able to do that because you're a magistrate, you are able to arrange your life accordingly.
Yeah, especially when I worked as only the head of office, Chief Magistrate of Randburg, because I was not doing full-time court work, so that became possible.
Yeah. You, in your capacity now as a regional magistrate, you do a lot more criminal work than civil, am I correct?
That's correct, CJ.
Yeah.
There is an element of civil work, but it's so little that, in fact, we have just allocated to one magistrate.
Yeah.
So the idea is that from time to time we'll just alternate, but as it stands, only one magistrate, so I do only criminal. And I can tell you it's hard in Soweto.
I know, I've been there. But here's what I want to suggest. Commissioner Gottsal has been raising the issue of the long lead times in Gauteng. You've acted in the High Court. You are aware that quite a big number of the matters that come to the High Court, especially in the unopposed motion roles, belong in the magistrates' courts.
That's correct.
Now, are you going to help us find ways of lawyers taking these matters to the magistrates' court? Because they actually don't mind. Even if they come to the High Court, you don't give them High Court costs, they still come to the High Court.
JP, I sat with you in PEC meetings. I know the discussions, what went on. I know what motivated you, for instance, to constitute a court that ultimately produced Mokebe decision.
Well, it produced a decision I don't like, but anyway.
Yeah, and despite all the best efforts, for instance, by the South African Human Rights Commission to take the matter to, it was the wisdom of the apex court that such matters can still come. I was just rereading the judgment yesterday, telling me that in fact the High Court, for instance, cannot refuse a jurisdiction to entertain a matter. But having said that, the rules board considerations are always given, for instance, around the issue of what can be done. For the High Court, we introduced Rule 41A. I think it's a rule that needs maybe to be revisited and maybe just to make it have teeth, because it has become apparent from me, at least, that it is just becoming a ticking box for lawyers. It's a tick box. Practitioners just tick that the matter cannot be mediated. As a result of which...
No, look, you don't have to go further. That's not why you are here.
Yeah, thank you.
Yes, this SCA and CC judges live in a different planet. Do you agree with me?
Oh, difficult to say.
Don't agree with me.
No, I don't.
I'm just saying that.
Yeah, no, just I want to leave it to you.
Yeah. In your acting stints in Gauteng, you've done 3 weeks of opposed motions.
That's correct.
As well as 1 week in the agent court.
That's correct.
And no allocations in the special motions. Right. And those are, especially motion court, opposed motion court, it's the difficult work area. And I told you before you went there that...
You told me so, JP.
Yeah.
And in fact, it's interesting that, I started when because of the COVID restrictions, so I was essentially all by myself.
Yeah.
I had to do most matters online, but I'm happy to say I think I acquitted myself well.
No, you did. You did, yeah. And in the course of you acting, you produced some 40 judgments.
That's correct.
That's what I have here. Now, what I've noted is most of your judgments are within a month to 2, but there are a couple, I think I marked 4.
That went beyond.
That went beyond the 3 months. 1 is 5 months, 2 are 4 months.
Yes. In particular, the 5 months one, JP, it involved medical negligence.
Yes.
It was what we call long duration trials of 10 days, and it lasted 10 days.
Yes.
Both the plaintiff and the defendant each had 5 witnesses on each side.
Yeah.
In addition to evidence witnesses that were called. So it really needed more time for me to consider, and I considered that.
Yeah.
And that is the rest of the other cases, and I know I received a call from you on a Sunday, JP, or on a Friday, but it was on the 26th of January when you were alerting me to a judgment, a TIPCON judgment, and I said to you it was ready. And by Monday I had delivered that judgment. The idea here is that I type my own judgment, I do my own editing. So at times, maybe out of self-deprecation, I tend to take longer, maybe just to once always read. Every time I read, there's a comma that I need to add or extract it. At the end of the day, but the task, and I'm aware, in instances where I went beyond 3 months, I profusely apologize for that, and it is mainly because of also the work. You'll realize most of those cases are the ones that when I was now already in the regional court. And I've told you that the regional court in Soweto also breaks the back. It's like we are in Johannesburg High Court.
Yeah.
Yes, JP.
Now, we had a magistrate, senior magistrate who appeared, who confirmed that your experience as a magistrate's court magistrate on its own does not equip you to take permanent appointment in the judiciary. He said that's correct. What's your view of that?
JP, I don't think I agree that it doesn't. Because at the end of the day...
I'm talking permanent appointment.
You mean?
Permanent appointment as a judge.
As a judge.
Yeah.
But that experience coupled with the acting.
I didn't couple with...
Or with, not coupling with...
Yeah.
Yeah, yes. If I just have to come to the magistrate's court...
Yes.
And right into the High Court, I believe there could be...
You need to act.
You need to act, yes.
Now, you've had the bulk of your experience as a magistrate.
That is correct.
Senior magistrate, and you were in Randburg before you came to the what do you call it, the regional court.
Yes, yes.
But you've only been there a year, or just over a year.
The regional court.
Yes.
Yes.
Yeah. So this is a question I ask you. Why do you want to come to the High Court? You've just been there a year. What motivates you to want to then come to the High Court directly?
Oh, directly. Yeah. Well, JP, the regional court is just a specialist court in terms of criminal work. The overall, to be a complete magistrate, if you're a district court magistrate, to me, makes a more complete magistrate, because all aspects of the laws or the areas of the laws, family, civil, criminal itself, are dealt with in that court. We know the history where the regional court comes from as a court, as a specialist criminal court.
No, but the regional courts have civil jurisdiction.
Yes.
Why don't they do a lot more civil work than they are doing criminal work?
JP, the reason that I can think of, and I've heard practitioners talk about,
yes,
is lack of experienced magistrates. Because when it was introduced, the bulk of the magistrates only had criminal experience. It is, of course, now that the Magistrates Commission is trying very hard to widen up the pool in terms of attracting, especially people from the members of the bar and the sidebar.
Yeah.
So.
Okay, but I'm not blaming you. I'm just saying that's the dynamic we see at PEC trials, that the work that comes to the High Court should actually be done in the regional court.
In the regional court, I agree with you entirely.
We would not have these long lead times if that was happening.
Yes, but it is one of those things that must be encouraged. But remember now, JP, the law as it stands now, the interaction is between the Magistrates Court and the High Court. I've tried to look both at the rules and the Act itself. The only time that a matter can be transferred, for instance, from the High Court is to the Magistrates Court. So maybe those are, with the powers that be around this table, something that can be legislated. And then,
no, the minister is here.
Yes, then that can be legislated. And,
so, just my last question. I'll come to you about my scoring matrix. Don't you think you could have done more in the acting stints, especially in coming for more acting stints to be allocated special motions to see how you handle them before you availed yourself? No? Because you've not had a special motion allocation.
Yes, I've not had a special motion. My general experience, JP, and I know the approach that you take, that one must have been exposed to all forms of the work. But my general...
The difficult work.
The difficult work.
Yes.
Yes, but I've handled urgent court, I've handled opposed motion. So if I have to have an opportunity of doing a special motion, I do not see how I will be unable to deal with it.
You see, because when I look at your spreadsheet,
yes,
you've only sat in one full court appeal. I don't know whether you wrote it. And
Yeah,
then,
I wrote, it was 2 matters. One was written by another senior judge, and I wrote the matter. The average case matter is the one I said.
And the numbers of the work you've done as an acting judge compared to other candidates who have sat there is quite low, because they've acted longer. And civil trials, you've only handled 2, right? So that's why I'm asking whether you think, like in Asian court, you've only done 1 week. If you'd done 3 or 4 weeks, I would understand. So that's why I'm asking whether you think you are ready, I should recommend you, or you think you could still benefit from more acting stints.
JP West said, I think I'm ready.
You don't agree? No, look, I'm not intimidating.
Yes. No, I agree with you, JP.
Okay. CJ, I don't have any further questions for...
Thank you, Judge President.
Yeah, thank you.
Premier?
I'm also covered, CJ. Thank you.
Thank you.
Thank you, Premier.
Any questions, Commissioners? Commissioner Mugaitu?
Thank you. Mr. Tupayatlas.
Commissioner Mugaitu.
Yes. Okay, I think
both our surnames are difficult.
I should accept the punch back.
Yeah, both our surnames are difficult, Commissioner.
Yes.
Thank you.
No, I'm not sure if I heard correctly.
Mm-hmm.
What did you say to the JP? Did you say you agree with him that you are not ready, or you disagree with him? What was the actual answer?
No, the actual answer is that I think I'm ready. I can do that.
You are ready now?
Yes, JP. I mean, and this is more fortified, for instance, by the comments that I got from the GCB and other law bodies.
Yes, and how many reported judgments do you have?
Reported?
Yes.
No, I only have published.
You don't have one? Yes, and you don't think that's a problem?
Commissioner Ngatobi, it could be.
Yes, all right. And then we've been looking at candidates who've acted for 60, 61, 62 weeks. And how do you fare on that one?
Yeah, no, I fare lower than them.
Yes. And we've also been looking at candidates who've been in practice. One of them was 36 years in practice as an advocate, particularly doing high court work, appeal court work, constitutional court work. And how do you fare on that one?
It is obvious that I fare lower.
Yes. Now, and these are the sort of core skills that this commission is looking at. And on those 3 yardsticks, you admit that you are below. But at the same time, you disagree with the JP that you are not ready. So
I'm just saying on the objective facts.
There's no problem of a self-assessment here.
Okay. No, I was just saying on the objective fact, just to say, I was heartened by the fact that for what I've done with the amount of time that I've had, I didn't have any negative comments in terms of the quality of my judgment.
I mean, and most of this can be solved because you can get more time and then come back. It's not as if they're inseparable.
I agree with you.
Yes, so that's why I was just asking about the self-assessment.
I agree with you, Commissioner. Thank you.
Acting President?
Good afternoon. Thank you very much, Chief Justice. Good afternoon, Mr. Tupayatlas.
Good afternoon, Commissioner.
There are two objections. One is from There's one from National Bar Council of South Africa. Their concern is that they don't think that you are ready because you haven't you don't have any experience in constitution litigation. Do you agree with that statement?
From which association.
It's National Bar Council of South Africa. It's a letter that they wrote. Can't see the date here, but yeah, it's an objection that it's a concern that they've raised.
Yeah, it's that paragraph 4 of their letter.
Do you see that? Paragraph 4.
Yeah.
You agree with that statement?
Yeah, the constitutional litigation specifically.
Do you agree with that statement?
Yes.
And then there is Law Society of South Africa.
Mm-hmm.
They are mentioning a complaint of bias. Did you see it?
Yes, Commissioner. And
you want to say anything about it?
After this came, and I sent this complaint was initially lodged with the DJP Sutherland. Investigated the matter. He didn't find me any merit. Later, I got a call from the JP also, and I also responded. Some 2 weeks ago, I received a letter from this body, the JCC, the mini JSC, saying that the matter, the CJ referred the letter to JP Mlambo and also investigated the matter. The word used there is that he found it to be frivolous.
Sorry?
He found the complaint to be frivolous.
Oh, frivolous. So it was dismissed. Okay.
Yes. So what I'm saying is I'm the one if you look at my application, when I applied, I did when under the general heading whether there is anything that I wanted to put forward that may put the judiciary into this report. I specifically mentioned that to say, I'm aware of this complaint, the DJP had dealt with it, but at a time I had not received a feedback from the office of the JP. So that is where we are. So what happened is that on the 25th, 25th of September, the remarks were sent to me. But at a time, our network had crashed, so I didn't see these other complaints. But when I ultimately saw it, I sought advice from the office of this OCJ office, and I advised that all that I did was to send the letter that had come from the JCC. So I thought that response answered the issue that was raised.
Okay. My last question is, based on the nature and the amount of work that you have done at the Gauteng High Court.
Yes, JP.
How would you, on a scale of 1 to 10, how would you score yourself?
On a scale of 1 to 10?
Yes.
Give myself 6.
6 out of 10. Okay, thank you.
Commissioners, on the virtual platform, do you have questions for the candidates?
Yes, I do.
Yes, Prof, go
Chief
ahead.
Justice,
Dumelarre Maruma, High Commissioner.
I just want to ask you about something that I've been thinking about in as far as civil work is concerned in magistrate court. I've realized of late that in the regional courts where divorces are done, most of the magistrates are reluctant to deal with maintenance matters that are incorporated into the summons where the divorce is actually sought. And this is mainly because the district court has a maintenance code. I'm not sure, what is your view on that? Is this not limiting these magistrates to be able to deal holistically with family disputes at a go and limit the chances of litigants spending more money by going from one court to the next? Because what I've seen is they tend to provide or to order a token maintenance so that the parties can later on go and fight their maintenance issue at the maintenance court. I'm not sure if you are aware of that and you have any views with respect to that.
Specifically, I'm not aware of that. There could be, and I take your observation, but I also agree with you that the ordering of token maintenance, which at the end now necessitates that a party must now approach the magistrates court, really in itself has an effect of delaying justice, if any. So where I sit, and because I know I'm in a training committee of magistrates, is something that I can take up to say, encourage magistrates, that regional court magistrates who are doing civil work, that they take a holistic approach of these matters.
That will really assist. Thank you very much. CJ?
Thank you, Prof. Well, thank you very much, Ndati. I'm scared to try to say your name. I suspect I'll damage it. Thank you very much for making yourself available for the interview.
Thank you, CJ.
Your excuse. Good afternoon, Advocate.
Good afternoon, CJ.
How are you?
I'm fine, in you, CJ.
Good. You studied at VETS?
Yes, CJ.
And obtained which degrees?
BA in philosophy and law, and then LLB and LLM.
An LLM in competition law and media law?
Yes, CJ.
But before you went to university, you did a whole range of things.
Yes, it's a convoluted history. It's a long history.
Yeah, yours is a truly remarkable story, I think. You worked as a farm worker, you were barely a man. You were just a boy, really, when you started working as a farm worker.
Yes, CJ, I needed money to go to to high school. I had
So
finished.
you left school before you finished your matric.
I beg your pardon, CJ?
I'm asking if you left school before you finished your matric.
Yes.
Mm-hmm.
But the farm stint was before I went to the high school, just finishing primary school.
Then you were golf caddy at some stage.
Yes.
And then you went to work in the mines.
Yes, the golf caddy was still during the time when I was still in high school.
Oh.
And then I ended up with the certificate called JC, Junior Certificate. And then I couldn't complete my matric. Then I went to work in the mines as a miner and a security guard.
How old were you then?
I was about 17 when I went to the mines.
And you worked underground, loading stone?
Yes, I worked underground for almost 6 months until an unfortunate incident where some of my co-workers lost their lives. Then I asked the security people to show me where the security office was, and I then asked for a job there because I was scared to go back underground.
Yeah, my goodness. How long did you work in the mines? I count, we say between 1981 and 1989.
Yes, I think I worked in the Barberton mines until 1989. Then I came here in Joburg in the same year, 1989, and I worked for a mine called JCI at the time in Randfontein as a security guard. Then I quit and went back to complete my matric.
That's commendable. And here you are today.
Yes.
All right. I see that you were quite active at the University of the Witwatersrand. You were a member of the SRC. You tutored undergrad law students, and you helped set up a center, the Wits Law Students Council Writing Center.
Yes.
What was that for? What did it do?
The writing center at the time, CJ, it was during the time when the LLB degree was now downgraded to the undergraduate degree. Maybe I was in the last group to do LLB as a postgraduate. Then we realized that people who were coming straight from matric to do LLB were struggling with assignments. And we then fundraise with other co-members of the Law Student Council, including Professor David Belches, who's acting in your court. And
not
also,
not anymore.
and also Professor Bonita Mesfeld, who's still at VETS. And with the assistance of the law firms, we then managed to establish that writing center. So how we ran it is the top student will then mentor the undergraduate students.
All right. Okay, then fast forward, you did pupillage in 2004 and directly thereafter started practicing as an advocate.
That's correct, CJ.
And you continued until you took silk in July 2020?
Yes, the recommendation was in 2020, yes.
So what kind of cases have you been doing at the bar?
My practice is a general practice, CJ. As you've seen in my application form, spread. I started with administrative law, mainly on mining, and then competition, and then medical negligence and criminal law.
And I see that you are continuing with what you started at university. You still mentor and train pupils and young members.
Yes, CJ, I'm a trainer in the advocacy training that is now it's convened by Advocate Makola SC.
And you also assist with moot competitions.
Yes, CJ.
And you are a member of the Johannesburg Society of Advocates Sexual Harassment Committee. What are the responsibilities of that committee?
We are trying to assist members who have been sexually harassed by co-members internally within the Johannesburg Bar Council. Yes.
Right. Are there any reported judgments of matters in which you participated as counsel?
Yes. There is one that is reported in the Competition Appeal Court and about 3 in the Gauteng High Court.
And you started acting as a judge in the Gauteng division?
Yes, and
when?
I think in 2019, but I started doing the pro bono ones. Until last year, I did 2 full terms last year. This year, I did 2 full terms.
The first and the second terms?
Yes.
So that's 3 full terms then?
Yes. And
Plus the pro bono work, you can't quite.
No, I haven't done any pro bono acting stint. All of them, I did the first and second term, and the third term was not entirely the whole term, but about 2 months of that.
Are you saying you acted pro bono throughout?
No,
all right. What did you say about pro bono?
I said this year I haven't acted pro bono.
Oh, all right. I was going to ask how you, well, who am I to ask counsel, senior counsel, that kind of question. You have written judgments in the High Court.
Yes.
How many?
According to my spreadsheet, I think I've got 43.
Mm-hmm.
Yes.
All right. In what kind of matters?
They vary, CJ, commercial and criminal, and I was sitting in full court, civil appeal court, full bench and full court.
Yes. Did you get to conduct any trials, civil or criminal?
Criminal, yes. During my third term, I was doing, my second term, I was doing criminal. I was in the criminal court.
How many criminal trials have you done?
5.
Mm-hmm. Completed them?
2, I've completed them. 3 are still part-head. I was dealing with one today, hearing evidence in respect of sentence. And the other one, I heard evidence in respect of sentence last week.
So you are acting at the Gauteng division of the High Court as we speak?
Yes.
All right.
And then there's one where I'm still dealing with the trial. That one is also part-head because I think I shot myself in the foot, CJ, because I exercised the court's right to call court witnesses in terms of Section 186.
Yeah.
And I still have to hear those witnesses next week.
When you submitted your application to the JSC Secretariat, you listed 8 reserve judgments, the oldest going back to September last year.
Yes, CJ, and unfortunately
What is the status of these matters?
Unfortunately, some of them were quite late, and it's regrettable, and I apologize. But one of the reasons is that I wrote those judgments, but I was waiting for my co-judge, who was not available to look at them. But as we speak, all of them have been delivered.
All 8?
All of them. The only reserve judgment that I have are the ones that I'm dealing with in my part-head criminal matters.
Or had you sat in with the appeals? All of them? I hear you speak of the co-judge.
About 2 of them I was waiting for the co-judge, and then the other one was my own delay. It was a review, but that has also been subsequently delivered.
That accounts only for 3. What about the other 5?
Let me just...
In which ones did you sit alone? In which ones did you sit with another colleague or colleagues?
Let me look at my spreadsheet.
You can just go to your bundle at page 19. That's where your application form is. Have you found the page?
Yes. The first one, I was waiting for my co-judge, and the second one.
And who was that co-judge?
I beg your pardon?
Who was the co-judge? Do you remember?
Yes.
Who was it?
Judge Kumalo. Yeah, and he He was engaged in the labor court at the
Alright.
time when I was looking for him.
Mm.
He was
And
in the
the
agent
second one?
court at the labor court.
Okay. And the second one?
Both. Then the rest are mine.
But 7 are yours.
Yes.
And why did you delay the judgments?
I think, CJ, I shot myself in the foot by acting for 2 terms consecutively, and I was not able to complete the judgment because I was also running my practice after the recess, and I postponed some of my arbitration to those dates, and I couldn't complete them on time. I couldn't complete them on time.
In fact, you can take numbers 6 to 8 off the list because the others were reserved just on the last day of April, and the other one was reserved in June. So it's the 5 that we were worried about, really.
Yes, and that's the reason, CJ, because although I've acted for most of the time this year, I didn't close my practice, and we agreed with JP that I shouldn't close my practice, but the price that I pay was also to juggle my practice with my acting stints, and that largely contributed to that. But as I said, CJ, it is regrettable and I apologize.
But they've been delivered.
Yes, all of them now, as I'm sitting here, they are all have been delivered.
Okay. JP Mlambo, do you have questions for your candidate?
Thank you very much, Chief Justice. Advocate Mkawela, good afternoon.
Good afternoon, JP.
Yes, you've been taken through your cases by the CJ. Mine is to help you show the Commission what you've done and where you've acted. I focus mostly on the difficult work areas. Your spreadsheet illustrates that you've done a total of 43 weeks acting. These are all stipendiary. No, I think the first 4 were pro bono, if I'm not mistaken. Am I correct?
Yes.
Thank you. You've done 6 weeks of opposed motions. I think you're the second highest in that range. And then, but you've done 1 special motion and 4 agent courts. Is that correct? You agree with that?
Yes.
And you also agree that agent court work is a difficult work area in Gauteng.
Yes, indeed, JP is very difficult.
Yeah. I would imagine, because I want to move on to your judgments, having done 6 weeks in the opposed motions as well as in the agent court, this is the reason that your reserve judgment record is not that pleasing. You agree with me?
Yes.
I can take you through. You've written, I'll tell you now, some 47 judgments.
Yes.
Yeah. And I want you to comment on this because it's only fair. You're a senior member of the bar. I've had other senior members of the bar coming to act, and they also have practices, but your record, you have, according to this, there are 5 judgments which took you 7 months to finalize. I can show them to you if you want.
No, I agree.
There is 1 that took you 9, I think there's 2 that took you 9 months. There's 1 that took 13 months. There's 1 that took 12 months. And I think another one that took 5 months. It's not that great. Do you agree with me?
Yes, Chief.
Now, these are the questions that this body asks itself to say the problem we have with reserve judgments needs to be addressed. And especially here when a candidate stands for judicial appointment, we check how the candidate has fared acting. You know, Judge President Mwepe used to say, this body must caution against creating permanent problems. What he meant was a judge becomes permanent, and if a judge has a problem with reserved judgments, that problem is permanent until the judge retires. You understand what I'm trying to say?
Yes, Chief.
So I'm raising all this in all fairness to you, because I want you to tell this commission what is it that will change. Because these reserved judgments are not only in one term, they straddle your whole acting career from when you started till recently. You've been picking up these, and the 12 months one, the 13-month one concern me. But what is it that you think will change, and what will make it change for us not to see this problem recurring should you be recommended for permanent appointment?
Thank you, JP. I think what will change is that I will not be juggling my practice now with acting. It has always been a challenge if you don't close your practice and you act for quite some time.
Yes.
You still have to do your private work, and that also could take you time.
Yeah.
But if I'm appointed permanently, that problem of taking time to deliver judgment is not attributed to a lack of ability to write them, but juggling practice and acting.
Yeah. A problem that I've identified, and I think I'm just raising with you, is, and I think it applies to you as well, you don't use the researchers to help you. Is there a reason why?
Recently, I've used them. All the judgments from this year, JP.
Well, I'm happy to hear that this year you have, because some colleagues of yours who act in the High Court don't use the researchers. And when I say use the researchers, is you don't ask them to write your judgments. You ask them to assist with the research underlying your reserved judgment.
Yes.
Right. So a lot of your colleagues prefer to do their own research, when it delays things. So you say this year you've started using them.
Yes, I started using them during my second term.
Yes.
One of the senior Judge Kuvaji, even impressed on me that they are quicker to assist us, and I found them very helpful.
Yes, they are quicker and they are very good. Just that they are overworked, and the minister is here. She knows that a division as big as Gauteng with about 84 judges relies on 12 researchers, So sometimes they battle to...
Yes, and they will tell you that give me maybe another 7 days or 8 days to retain your judgment, because they are not only dealing with you alone.
Yes.
Yeah, but they are helpful, JP.
Okay. So, in all fairness to you, out of 5, how would you score yourself for reserve judgment? You see, my scoring matrix is, if you've delivered all your judgments before the end of 3 months, I give you the total, that's fine. If you have some that have gone over 3 months but less than 6 months, you go to 4. You go beyond 6 months to 9 months, you go to 3. Beyond 9 months over, you go to 2. The score decreases the longer you take with your judgment. Taking account of your own record, where would you score yourself?
Objectively, JP, my own record will be 5, because some of the delays I was waiting for my court judges.
All of them?
The one that
you mentioned
longer, the one that are longer, the longest one I was waiting for my court judge.
Okay, so the 2, the 12-month and 13-month one?
Yes.
Okay. But the others are yours?
Yes.
Okay. Okay, thank you very much, Chief Justice. I've got no further questions.
Thank you, JP. Premier?
Thank you so much, Chief Justice. Good afternoon, Advocate Mkawe.
Good afternoon, Premier.
I was checking with JP, that this is the Mukabela I know, because ever since I became a member of this, I've been confronted by application. So I just want to wish you well. Thanks.
Thank you.
Oh, sorry. I'm reading emails from work. I'm juggling my constitutional court emails and this interview. Some of the things we have to do. Questions, colleagues? JP Tlaletsi.
Thank you, Chief Justice, and good afternoon, Mr. Mukabela SC.
Good afternoon.
Yeah, I just want you to clarify something, lest there be any confusion. And I do appreciate that it's quite difficult being a single practitioner or an independent practitioner to allocate such a lot of time to act, which every head of court would gladly accept and wish to have. But now please clarify, if you say you did not close your practice during the period, if I did understand, hear you well, does it mean you're also practicing? And what kind of practice, if that is the case, were you appearing in court, representing clients, and also being an acting judge? Just to clarify that, thank you.
Thank you, Chief. No, I was not appearing in court. I was just dealing with some drafting and reading.
Thank you.
Acting President Zondi. You
Sorry, no,
drawing
I don't have
attention
a
to him?
question. Yeah, I was just drawing your attention to
No more
JP
hands
Tlaletsi.
here. Okay, thank you, AP. Commissioner Hassan.
Thank you very much, CJ, over here, Advocate. Mine is less of a question and perhaps more of a comment. Just on maybe on a lighter note, I was also not too long ago a student at Wits University, and I quite regularly attended the law writing center. So it's on a lighter note to meet some of the people who founded that program. Sometimes it helped me, sometimes it gave me more anxiety, but not because it was inefficient, more because I was always a last minute kind of student. CJ, that was it. I'm very comfortable with the line of questioning that the JP and yourself led. Thank you.
Thank you, Commissioner.
Commissioners on the virtual platform, do you have questions?
Thank you very much, CJ. Good afternoon, Advocate Mukabela.
Good afternoon, Commissioner.
Did I hear you correctly that amongst others you also do commercial arbitrations?
Yes, that's correct.
Yes. Yes. Can I please ask you, because it seems to me that a lot or some or most of the business people are choosing not to give the High Court or the courts generally an opportunity to develop jurisprudence in that area of law. And they choose to do that kind of work privately. And you find that the awards that are granted, they are shrouded with secrecy. So we don't know how actually this thing works. What do you think should be done to expand the expertise in as far as arbitration work is concerned, and ensuring that at least the courts get the bite at it, and so that the jurisprudence relating to that kind of work can actually grow? Do you think there is something that can be done under those circumstances?
Thank you, Commissioner. I think what could be done maybe to codify the jurisprudence that is developed in the context of private arbitration. Maybe if there can be our own law reports that can be accessed by law students and stakeholders, that will help. But as far as expanding arbitration is concerned, the AFSA conducts a number of training, and people are always encouraged to attend and acquire the necessary skill. And recently, The JP is on record to encourage litigants also to make use of arbitration and mediation prior to approaching our courts. So if that advice is heeded, it will go a long way.
Thank you very much, Advocate Mkabela. Thank you very much, CJ.
Thank you, Prof. No more hands. All right. Thank you, Advocate.
CJ, can I say something to the candidate?
Oh, yes.
Advocate Mkabela, your history at being a farm hand at a very early age reminds me of a very painful part of my history. My father, when he was of the age, around 7, where the farmer expects the children of the people who live on the farm to work on his land, when he was of that age, he refused to go work at the farm, and he'd heard that you can get an education. And because of that, the farmer evicted them from the farm. They spent the next 2 years being homeless. So that's the chord you touch in me. You come from those roots, and you are here today. I want to applaud you for that. Thank you, CJ.
Thank you, JP.
Okay. Well, thanks very much for making yourself available for the interview, Advocate. You're excused.
Thank you.